So I'm going to just start by telling you a little bit of history of how this book came to be and the kind of questions it addresses as sort of to get in view whatever we could be meaning by the Constitution in 2020. The project actually began when we learned about some documents of the Mies Justice Department of the Reagan years. And these documents were called the Constitution in 2000. And we learned about, some of us learned about these documents in the early 2000s. Others knew about them earlier. And what was the Constitution in 2000? The Constitution in 2000 was an effort to set forth an understanding about constitutional law that would guide both litigation and appointments for the Reagan administration in the 1980s. I think the documents are dated 1988. And these documents essentially set forth what the Department of Justice then saw as choices in interpretation of the Constitution, identifying lines of cases that they understood to be rightly and wrongly decided, and said that those who were concerned with matters of judicial philosophy, and particularly original meaning, would be concerned to preserve the rightly decided lines of cases and to resist as wrongly decided and political these other lines of cases. And the cases concerned matters which will sound familiar to you: separation of church and state, prayer, privacy, the contraception and abortion cases, issues of constitutional protections for criminal defendants, issues of race and equal protection, issues of federalism and the power of Congress to enact civil rights law, issues of executive power and takings. And essentially, these documents were setting out a blueprint for change in constitutional law, but presenting this as a process of working the Constitution pure or clean. And when some of us were learning about this in around 2000, 2003, what was truly the most riveting about the documents was that the law in the interim had bent to conform to the so-called rightly decided lines of cases and away from the so-called wrongly decided lines of cases. And seeing both the Constitution in 2000 documents and also the fruit of this work, some of us on the panel knew about it for longer than others of us. Nonetheless, I mean, it was just riveted the attention. It was a work of clarity, of intellectual power in a certain way, and it reflected a kind of nerve. So what did we do? Well, I think one of the things that struck a number of us was that at the time that we were, at least some of us in the academy, were learning about this as opposed to the other of us in Washington who might have known about it, there was just some sense that there was a lot of criticizing of judgments of the court, but there wasn't a lot of effort to say affirmatively what the law rightly understood might be. And this project emerged out of the effort to engage in a grounded effort to state what our best understanding of the Constitution might be in a range of areas of law ourselves.